When something is like a Rembrandt, it's not a Rembrandt. When something is like a Picasso, it's not a Picasso. And when something is like a gun, but not a gun, it's not a gun. That's what the ATF and the Department of Justice and Merrick Garland found out today when the United States Court of Appeals for the Fifth Circuit upheld the district court's decision slapping down the major part of the quote-unquote ghost gun rules promulgated by Joe Biden. Big win for the Second Amendment. Stay tuned for more details. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, and constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out on Audible, Kindle, and paperback. Also, don't forget to follow me on @4boxesdiner on Twitter. Okay, folks, major win today, major win. The appellate court, the United States Court of Appeals for the Fifth Circuit, covering the states of Texas and Louisiana, rejected, for all intents and purposes, the essential part of Joe Biden and Merrick Garland's quote-unquote ghost gun rule. Now, as a reminder, under current law, as the way the ATF, the way the ATF has historically interpreted the Gun Control Act of 1968 as to what constitutes a firearm, it's the frame or a receiver, specifically the frame of a handgun or the receiver of a long gun. What the Joe Biden administration did, what they consider to be really the centerpiece of the Biden administration's anti-gun ATF policymaking, which is the Barack Obama notion of, I'm the president and I can govern with a pen and a phone. That's all I need. Well, Joe Biden has tried it. Obviously, he got terribly spanked a few weeks ago by the U.S. Supreme Court in his attempt to do student loan forgiveness of $430 billion without going to Congress. And again, today, he was spanked badly by the United States Court of Appeals in the context of gun control. Because again, what Joe Biden and his Department of Justice and Merrick Garland did, and the ATF did here, is they tried to expand the definition of what a frame or receiver is, or a firearm is, to include essentially component parts of these, i.e., parts of things that could be readily converted into a firearm or into a frame or receiver. All of a sudden, Joe Biden wanted to regulate and have covered by the Gun Control Act of 1968. They redefined frame receiver firearms in such a way to capture parts of firearms, including so-called weapon part kits, which again are parts of guns. And again, as I pointed out in the opening of this video here, if it's like a Rembrandt, it's not a Rembrandt. If it's like chicken, if it tastes like chicken, it's not chicken. If it's like a Picasso, it's not a Picasso. And so too, if something is like a frame or like a receiver or like a firearm, that doesn't make it so. And Joe Biden has just learned this. So what happened, just to bring up the speed, if you haven't remembered this. So what happened here is that in this major case of Jennifer Vanderstuck, Firearms Policy Coalition Incorporated, Second Amendment Foundation Incorporated, not an LLC, doing business as JSD Supply Polymer 80 Incorporated, Black Hawk Manufacturing Group, and Jennifer Vanderstuck versus Merrick Garland and Steve Dettelbach, Department of Justice and the Department of and the ATF. That's the case. Several weeks ago, the United States District Court in Texas concluded that this regulation that Joe Biden tried to sneak through was illegal because the ATF had exceeded its statutory authority. And just to remind you how this works, the way it works is Congress passes a law signed by the president that becomes a federal statute. That's the law of the land. Then executive agencies, whether it be the ATF, the FDA, the EPA, the Department of Education, whatever it is, they can go out there and on certain occasions can promulgate regulations that fall within those statutes, within those federal statutes. But here's the key. Those regulations have to be consistent with and fall within the scope of what Congress's statute has given the authority of these agencies. So what happened here is that Congress made clear that a firearm is essentially, frame or receiver, under the Gun Control Act of 1968. That was how it was always understood. That's how the ATF has always understood it. And specifically, Congress made clear that it wasn't about parts that went into these things, and the regulation of the parts was not allowed. Nevertheless, Joe Biden was upset by this, and he knew he couldn't get anything through Congress along these lines, so he asked the Department of Justice to redefine these terms. And of course, the United States District Court in Texas concluded that these regulations that expanded the definition of a firearm and expanded the definitions of frame and receivers, these expanded definitions were effectively a form of lawmaking, and they were done all in excess of the ATF's authority because they conflicted with the clear language promulgated or created by Congress of the Gun Control Act of 1968. So the little sleight of hand that the ATF did here is the ATF and Congress said that things that could be quickly converted into a weapon capable of expelling a projectile is a firearm. And that is something that could be regulated. But what they did not say, they specifically said that regulations that cover things that could be converted into a frame or a receiver are not covered. So that's fine distinction is what Joe Biden tried to take advantage of because his goal is to regulate quote-unquote ghost guns, which are nothing other than as Joe Biden trying to do it, nothing other than parts of guns that they want to have serialized so they can track and whatnot. And basically you can't buy parts without going through an FFL and getting a background checks because if the definition of a firearm includes parts of firearms, and all of a sudden parts of firearms become a firearm, when you transfer these things, at least according to what Joe Biden wants, is you'd have to fill out a 4473 and go through an FFL just like you are buying a full-blown gun. But of course, they wanted to apply to gun parts because they don't want us to be able to exercise our right to make our own guns. Because as you know, the right to keep and bear arms presupposes that we have the right to acquire guns. And there's a couple different ways you can acquire guns under the Second Amendment. One is, of course, you can buy them. Another way, of course, is you can make them. But again, what Joe Biden was trying to do is to try to use existing laws from the 1960s that had no interest in preventing or stopping ghost guns or guns that you were made at home without a serial number and try to misconstrue this statute and was hoping for favorable judicial rulings, which he probably would have gotten in front of some crazy anti-gun judges in other parts of the country. But down there in Texas, that did not happen. So the U.S. District Court in Texas said that these weapon parts kits were not firearms, and that as a consequence, the Biden regulation here was not allowed under the law. Specifically, it lacked the legal authority to promulgate these regulations because the statute promulgated or created by Congress did not give them that authority. So that was a major win down there in the United States District Court for the District of Texas. An appeal was taken to the United States Court of Appeal for the Fifth Circuit, and the happy news is that the Fifth Circuit, for all intents and purposes, upheld the lower court's decision that the ATF lacked the authority to redefine gun parts or weapon part kits as firearms under the Gun Control Act of 1968. So, for all intents and purposes, the ghost gun regulation promulgated by Joe Biden has been destroyed by the United States Court of Appeals for the Fifth Circuit, saying that the ATF lacked this authority to do what they did. Now, I will say that the decision by the United States Court of Appeals for the Fifth Circuit also has given the Department of Justice, I think, 10 days to seek certiorari, to seek some sort of a stay from the United States Court of Appeals. It's going to be interesting to see whether or not they do that, because in some respects, the ATF did have a little bit of a win in front of the Fifth Circuit because the entire rule was not 100% thrown out, but the critical portion of it, i.e. the definitions of what constitutes a frame, what constitutes a receiver, and what constitutes the firearm, that was thrown out by the lower court, district court, and the Fifth Circuit did not disturb that. And they said, yeah, we don't think there's anything wrong with what the district court concluded with respect to those definitions. It doesn't appear to us that ATF or the federal government has authority to redefine what Congress says or longstanding ATF regulations. Therefore, Merrick Garland, Steve Dettelbach, ATF, Department of Justice, go pound sand. Nevertheless, the Fifth Circuit says, look, but we like to play fair here, so we're going to give you 10 days to go to the Supreme Court, if you wish, to try to see if the Supreme Court will disagree with us. It's going to be very interesting to see whether the Department of Justice seeks certiorari or rushes up to the United States Supreme Court for some sort of administrative emergency stay, because, of course, the downside from DOJ's point of view is that they do this and the Supreme Court just blows them off and says, denied. That's going to make DOJ's rule look even worse, as if Joe Biden yet again exceeded all of his presidential authority, which he certainly did here in the name of gun control. Nevertheless, he refuses to go to Congress to enact these kinds of laws because he knows he cannot get them through. So bottom line is, major win for the Second Amendment today. The quote-unquote federal ghost gun regulations promulgated by Joe Biden have been gutted for the moment. They were gutted by the district court. The Fifth Circuit Court of Appeals, a major court of appeals in this country, reaffirmed for all intents and purposes the decision of the district court. And let's wait 10 days to see if Merrick Garland and the ATF goes to get relief from the U.S. Supreme Court. I'm guessing that they won't do that, but if they do, it'll be interesting to see if the Supreme Court slaps them down and it blows them off, which I think is what will happen. And I think Merrick Garland knows this, which is why I think they're not going to seek emergency relief from the U.S. Supreme Court. But again, we will know more in the next 10 days to see how DOJ reacts and what the Supreme Court does. I will also let you know that this case has been set down for an expedited hearing by the Fifth Circuit on the merits. We do not have a briefing schedule yet. We do not have the date of the oral argument yet. As that develops and as that information becomes available from the court, I'll try to bring it to you as soon as I can. But in the meantime, great win for the Firearms Policy Coalition, the Second Amendment Foundation, and to those other plaintiffs in this case. Good job. That's great news, because ghost guns is a political propaganda term for Americans having the right to keep and bear arms, and specifically the right to make guns as the means by which they can acquire them, in addition, of course, to being able to buy them from, let's say, gun dealers. Okay, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.